Welcome to Law Crest, your trusted source for legal awareness and U.S. law education. Today's topic is one of the most important and controversial legal questions in America. When can the police legally use force? In the United States, the use of force by law enforcement is governed by a combination of constitutional law, federal statutes, state policies, and court decisions, all of which aim to balance public safety with the protection of individual rights. The power to use force, including physical restraint, non-lethal weapons, or even deadly force, is one of the most serious responsibilities given to police officers. And it is tightly regulated under the Fourth Amendment of the U.S. Constitution, which protects citizens against unreasonable searches and seizures. In simple terms, this means that any force used by an officer must be reasonable and necessary under the circumstances. The cornerstone of this legal principle comes from the U.S. Supreme Court case, Graham v. Garner, 1989, which established the objective reasonableness standard. This means that an officer's use of force is judged not by their personal intention, but by whether another reasonable officer, in the same situation, would have acted similarly. The court emphasized that officers often must make split-second decisions in tense and uncertain conditions. Therefore, the question isn't whether the officer made the perfect choice, but whether their actions were reasonable based on what they knew at the time. This legal test is crucial because it protects both the public from abuse of power and officers from unfair judgment after the fact. The use of force continuum is a common guideline followed by police departments across the U.S. It ranks different levels of force and matches them with the level of resistance or threat faced by officers. The basic levels are 1. Officer presence and verbal commands to empty hand control, like holding or restraining a suspect. 3. Non-lethal force such as pepper spray, tasers, or batons, for hard empty hand tactics, physical strikes or takedowns. And 5. Deadly force firearms or other potentially lethal means. Officers are trained to start with the lowest level necessary to control the situation and escalate only when absolutely needed. For example, if a suspect is cooperative, verbal commands should suffice. But if a suspect resists arrest or threatens others, officers may lawfully increase their use of force proportionally. Deadly force, the most serious level, is only permitted when an officer has probable cause to believe that the suspect poses an imminent threat of death or serious physical injury to the officer or another person. This principle was clarified by another landmark case, Tennessee v. Garner, 1985, in which the Supreme Court ruled that police cannot shoot a fleeing suspect unless that person poses a significant threat to others. In other words, deadly force cannot be used simply to prevent escape. It must be a last resort to save lives. For example, if a suspect is unarmed and running away, using a gun would be unconstitutional. But if the suspect has a weapon or is about to harm someone, deadly force may be legally justified. Every police department in the U.S. is required to have written policies and training on the use of force, and many require body camera recordings during encounters. Officers must justify their actions in written reports and sometimes in court. If their use of force is deemed excessive, they can face criminal charges, civil lawsuits, or departmental discipline, including suspension or termination. 2. Under federal law, particularly 18 U.S. Code 242. It is a crime for anyone acting under color of law, which includes police officers, to willfully deprive someone of their constitutional rights. If an officer uses excessive or unnecessary force, they can be prosecuted by the Department of Justice and face imprisonment. De-escalation is another critical aspect of modern policing in America. Law enforcement agencies are increasingly training officers to calm situations before resorting to force. This can include verbal persuasion, negotiation, maintaining distance, or calling for backup. Many states have passed laws requiring de-escalation training and the use of non-lethal alternatives whenever possible. The principle is simple. Force should always be the last option, not the first. Even when force is justified, it must stop as soon as the threat ends. Continuing to use force after a suspect is subdued or handcuffed is considered excessive and illegal. The U.S. also differentiates between types of force: non-lethal, less lethal, and lethal deadly. Non-lethal force includes tools like tasers, rubber bullets, beanbag rounds, or pepper spray. These are intended to incapacitate, not kill. However, even non-lethal weapons can cause serious injury or death if misused, so their deployment must still meet the reasonableness standard. Police departments are required to track and report every use of force incident to ensure accountability and transparency. When force results in injury or death, it triggers an internal investigation and often an independent review by prosecutors or oversight boards. Many jurisdictions have civilian review boards to examine cases of alleged police misconduct. Victims of excessive force or their families can file a civil rights lawsuit under 42 U.S. Code, Section 1983, which allows citizens to sue government officials for violating their constitutional rights. These lawsuits can lead to compensation for damages and force departments to reform their policies. It's also important to understand that different levels of government, local, state, and federal, all play roles in regulating police conduct. Local police follow city or county policies, while state laws establish minimum standards for training and discipline. The Department of Justice (DOJ) can intervene under pattern or practice investigations, where it examines whether a police department shows a consistent pattern of violating citizens' rights. If found guilty, the DOJ can enforce consent decrees, legally binding agreements that require departments to reform. Certain high-risk situations, such as traffic stops, protests, or domestic disturbances, are known to escalate quickly. Police are trained to assess threat perception, considering the suspect's behavior, environment, and potential weapons before deciding to use force. However, bias-based or discriminatory use of force, such as targeting individuals due to race or background, is strictly prohibited under both the Equal Protection Clause of the 14th Amendment and federal civil rights laws. Accountability mechanisms have grown stronger in recent years. Many states now require that all police use of force incidents be reported to national databases. Body cameras, dashboard cameras, and bystander videos have become key evidence in court. These tools help determine whether the officer's use of force was justified or excessive. Transparency has become a cornerstone of maintaining public trust. While the law allows officers to protect themselves and others, it does not give them unlimited power. The guiding legal phrase is necessary and proportional force. This means that the force must be directly related to the threat level, not excessive or vengeful. For example, if a suspect resists arrest without a weapon, using a firearm would be disproportionate. The same principle applies to crowd control or protests. Police can use tear gas or batons only when a crowd becomes violent, not to silence peaceful demonstrators. The U.S. Supreme Court has consistently reinforced that each use of force must be judged based on the totality of circumstances. Factors such as the severity of the crime, whether the suspect posed an immediate threat, and whether they were resisting or fleeing are all taken into account. Courts avoid hindsight judgment and instead evaluate what the officer reasonably perceived at that moment. This ensures that decisions made under pressure are not unfairly condemned after the fact, while still protecting citizens from abuse. However, when officers cross the line, using unnecessary or excessive force, the consequences can be severe. In recent years, numerous cases across the U.S. have led to criminal prosecutions, multi-million-dollar settlements, and reforms in police training. The goal of these legal standards is to ensure that every use of force is accountable, transparent, and aligned with constitutional protections. In summary, police officers in the United States can legally use force only when it is necessary to protect life, maintain public safety, or enforce lawful authority, and that force must always be reasonable, proportional, and justified under the circumstances. They are empowered by law to act decisively, but also bound by the Constitution to respect the rights of every citizen. Excessive or unjustified use of force is not only morally wrong, it's a federal crime. So, whenever you see police action, remember this balance. Officers have the power to enforce the law, but the law itself limits that power. The justice system's ultimate goal is to protect both public safety and individual liberty, two pillars that must always stand together. This is Law Crest, helping you understand how the law truly works, protecting justice, accountability, and your rights as an American citizen.